Good afternoon, ladies and gentlemen. As you're aware, the Fijian government has rolled out an unprecedented package of health protective directives in the interest of stomping out the spread of the coronavirus, including targeted lockdowns of high-risk areas, a nationwide curfew, and certain business shutdowns. These directives are vital. They're proven to work around the world, and they're saving Fijian lives. The decision by the Nadi Magistrate Court yesterday regarding the breach of the nationwide curfew is deeply flawed and disconcertingly seems to miss the substance of the matter, which pertains directly to the health and well-being of the Fijian people. The curfew order and our other health protective directives are simple and straightforward. The curfew is in effect from 8 p.m. to 5 a.m. every day. During that window, all Fijians need to stay off the streets and refrain from traveling. This order was made by the Minister and Permanent Secretary for Health under the Public Health Act and published in the Government Gazette 12 days ago on 4th of April 2020. As stated before, orders under the Public Health do not need to be gazetted as long as they are made known to the public. Nonetheless, the orders were published in the Government Gazette. We note rather disturbingly that the magistrate in question failed to consider, let alone refer to these orders, even though they were published 11 days before his ruling, and the persons were charged 6 days after the publication of the orders. These orders were initially announced in nationally broadcast press conference by our Prime Minister. To claim that this announcement by the Prime Minister dilutes their legal standing is baseless. All over the world, similar health protection directives have been announced by heads of government. This is done to ensure maximum exposure and public awareness of new public initiatives in a time when the virus and its impact on society is rapidly evolving. Even in times of calm, not crisis, it is common and common sense that a head of government publicly announces major policy initiatives even if the legal authority rests in a different ministry or department. The decision by the Nadi Magistrates Court pertained to 2 individuals who admitted to violating the nationwide curfew on 15 April 2020. The charges were erroneously dismissed, not on the basis of the law's validity, but on the basis of how the prosecuting officers drafted them. This is a matter of form, not substance. No doubt, the Police Prosecution Office could have drafted the charge more clearly, referencing the order from the Minister for Health rather than referring to the Prime Minister. However, that charge could have easily been amended or fixed at the request of the court, as is common practice, so long as it does not in any way prejudice the interests of the accused. In the interest of justice and public health, this is clearly what should have taken place in this instance. These 2 gentlemen admitted to the offense. It defies logic then that the charges were hastily dismissed by the learned magistrate on the basis of an easily correctable charge. A number of magistrates throughout Fiji have properly applied the law and facts to similar cases. The flawed decision by the magistrate in Nadi in no way jeopardizes the enforceability of the Fijian government's health protection directives. These directives are saving lives, Fijian lives, every day. And those who violate these directives will continue to be arrested and prosecuted. Regardless of who announces these directives, legal authority rests with the Minister for Health and the Permanent Secretary for Health, which nobody has usurped. Meanwhile, with the eyes of the nation and the Prime Minister for decisive leadership, any changes under the Public Health Act will be announced by him so that it reaches the widest possible audience and is given the utmost attention. It is unfortunate that the magistrate deviated from the standard court practice of allowing the charge to be rectified, more so given the wide publicity in the public interest in ensuring that the law and the charges made under the Public Health Act are enforced in these extraordinary times. Any legal practitioner with even a rudimentary understanding of criminal procedure would know that in such situations, charges can be amended rather than be dismissed in such a hasty manner. We understand this same magistrate made a similar ruling yesterday. We've had discussions with the Commissioner of Police on how these fundamentally flawed rulings can be expeditiously reviewed through an appeals process. Thank you. Do you have any questions?
Minister, Edwin from FPC News. Just in regards to the initial ruling itself, as Minister for Justice, have you made queries or tried to find out why the magistrate took the approach that he did and the decision being made consequently?
We obviously don't speak to judicial officers. We can only go by his ruling, which is what I have in my hand. And obviously it is flawed in respect of the manner in which it was dealt with the decision itself.
Has there been any discussion on whether there would be correspondence with the Chief Justice to see that going forward there is some light given to the Gazette and the powers that now rest with the Minister for Health?
I mean, the Chief Justice obviously runs his own affairs in the judiciary. We obviously can make comments and observations about it. We can obviously go through the appeal process. But it is very unfortunate that the Magistrates Court in Nandi has taken this ruling, which is fundamentally a huge departure, both from practice and indeed the application of the law. I mean, you look at the ruling over here, you have these persons being arrested on the 10th of April, ruling given on the 15th of April, the Gazette notice on the 4th of April. And guess what? In this ruling, there's absolutely no reference to this Gazette. That is all the orders. And the orders, as you can see, when they were first announced by the Honorable Prime Minister, goes back to 19th of March, the different respective orders that were given, 19th of March. We had 23rd of March, 19th of March, 25th of March, all these different days in which new orders had come into effect. No reference whatsoever to it.
So do you know why there was no reference to the Gazette? Because the charges itself relate to that Gazette.
We hope that an appeal process or some review by the judiciary themselves will be able to find out what was amiss by this particular magistrate. Because as I've said, that all the other magistrates in Fiji have applied this law. Everybody understands the seriousness of what is happening in Fiji. All of you are standing away so far away. This never happened in press conferences in Fiji before. You're all standing away from each other, some of you wearing masks and gloves, etc. Everybody knows what the situation is in Fiji. Everybody knows precisely why these orders have been put in place. And as I've said, as far as the law is concerned, in terms of practice, the actual magistrates do allow, when they know what is actually happening, they do allow amendments to charges. In particular, if it's not going to prejudice those people who have actually been, charged.
So in the ruling, the magistrate says that he's found nothing in the gazettes that gave the Prime Minister any powers to call out curfews or give directives towards curfews.
I think you just answered it yourself. The reality of the matter is that these gazettes are made available to everybody. The reality of the matter is that if you look at the specific notices under this gazette that has been published about curfew, etc., you have one here on the Greater Lautoka area, Greater Suva area. You look at the substance, you look at the facts that were presented by prosecution, they're exactly the same thing. So why he deviated? What was the reason for deviation? That's something hopefully that we can find out through an appeal process, or the Honourable Chief Justice can enlighten us about it.
Good morning, sir. I have two questions. The first of which, can you explain the implications that the gazetted declaration of natural disaster on the pandemic now has on the government's powers in terms of how this relates to what you can do now?
It's governed by the Natural Disaster Management Act. Please read the Act.
And
it essentially allows the Permanent Secretary for National Disaster Management to be able to garner resources, to be able to ensure that those areas that have been affected in this one particular instance by Cyclone Harold, those resources get directed towards those areas.
And with respect to that declaration being for COVID-19, does this mean that the Permanent Secretary for Disaster Management can garner public state resources for the pandemic?
We're already doing that.
Okay, so how is this different is my question.
No,
how much
it gives
more?
a particular emphasis in respect of providing a particular level of emphasis in respect of garnering resources. I mean, we obviously normally, what you have in this particular situation, in recent history, in your lifetime, in my lifetime, we never had such a pandemic. So obviously it requires extraordinary measures in respect of garnering resources, etc. It also tells the rest of the world how seriously we are taking this particular pandemic. And there needs to be, for example, if there is a situation that requires a lot more resources expeditiously, very quickly, you don't have various permanent secretaries then breaching the standard operating procedures. So if, for example, something extraordinary is required, like the next 2 hours, so the permanent secretary for natural disaster management and the council, the National Disaster Management Council, can quickly go and grab resources. So, for example, if they come and grab vehicles from the Solicitor General, he has the legal powers to be able to do that. He won't be in breach of any of the public service, regulations, etc. That's what it is there for.
And as per the NDMO Act, the government is meant to make an announcement, a press announcement of the declaration of natural disaster pertaining to the pandemic, but you have not done that.
Honorable Usamate is dealing with that. He already made the announcement in respect of Cyclone Harold. I understand that may have already been made regarding COVID-19, or it may be made very soon.
Okay. And are there any implications on that law with regards to the arrests that you've made with curfew breaches and things like that? Does the NDMO Act now give you certain powers with regards to the curfew breaches and arrests?
You're confusing yourself.
I'm asking for your clarification,
sir. No, you're confusing yourself. If you read the Act itself, that's about garnering resources. Regarding public health order issues, obviously it comes through the Permanent Secretary for Health and the Minister for Health.
And a final question, the second question. Is it not improper, sir, that you, as a member of the executive arm of government, criticizes the judiciary with your comments?
I can criticize a particular ruling. Anyway, you're entitled to criticize a particular ruling. I'm criticizing a particular
I'm
ruling.
an ordinary person, so I'm asking if it's
an
proper
ordinary
for the
person
AG.
can also criticize a ruling. I can criticize a ruling. Obviously, I can't hold the court in contempt, but I can criticize a particular ruling. Of course I can.
So just going back to the issue of the charges being, or the suspects, or the outcome of the case, excuse me. We've identified, as you mentioned, that the initial error was in how the charges were drafted. You said you had a discussion with the police commissioner. Has there been any discussion on future prosecutions and those still in court being re-looked at to ensure that this does not happen again?
Yeah, we understand that the drafting of the charges in this manner is very far and in between. So it's very far. I think, sorry, I should say very few and in between. Not very far, very few and in between. I understand most of them have actually had the charges drafted correctly or, properly. In this particular instance, there was a flaw in it, and of course, it could have been amended given the intent of what was there. But we understand there's not that many of those types of charges being drafted in that particular manner.
There's something apart from this FNPF, there's still some employers out there who are not signing onto the forms, and there are some employees who've been without work for 3 weeks. I can name a few if you want. There's out there, they have no money to travel to come to the city or to buy food for their children or for their families.
Please bring that to our attention, because we are getting those calls too, so I refer them directly to FNPF and they approach those people. And again, I urge all, through the media, urge all employers to please, as we've said, that even if you have not been up to date with the FNPF payments, please, you should issue those letters to your employees. because FNPF, as we announced, that has agreed to, for the time being anyway, overlook those anomalies by the employers, as long as the employees are able to access those funds.
Sebula Tanjay from F96. You said, as you've said, you can comment in relation to the rulings of different magistrates. Of course, we've had a lot of people breaching curfew regulations, and we've got a lot of magistrates coming with rulings of different fines. Some are coming with $2,000, like in Nosuri, but others few $100 bail. What's your comment in relation to that?
Well, again, I mean, we think that there could be consistency, and we hope that the judiciary will look at this. This ruling, I think, will also put the spotlight on the magistracy, and hopefully that they'll be able to, look at how they're giving these rulings. And you're absolutely right. It is very disconcerting when you have similar offences under the same act, the same orders are being breached, and you have such huge, widely varying sentences being given, and hopefully that there'll be some consistency in that, because the public is entitled to consistency. And also, we need to have a deterrence effect, because these orders aren't made willy-nilly. It's not an easy thing to, for example, do lockdowns. It affects everybody. It affects government. It affects revenue. It affects people's jobs, people's lives. And if you have the magistrate not being consistent and not having the idea of having deterrence, then obviously, they need to look at it quite closely in terms of how they are applying the law.
So how quickly the appeal will be done?
Sorry?
How quickly the appeal
Well, we hope to do that extremely quickly and have an expeditious approach to it. So the Commissioner of Police, we understand, is talking to the DPP.
And what is the message to the public, where some people are saying the charge is not valid, however the Public Health Act is clear? Your message to those who are doubting this?
I've already said that in my statement, that you will be arrested, and you will be brought, you will be charged, and you will be brought before a magistrate's court for breaching the law, because the law is quite clear.
So just in relation to the assistance that people can tap into, affected by COVID-19, those that do not have FNPF account, they do not have funds in FNPF. We've mentioned about informal sector, but those that do not have business or hawkers license, what assistance is there for them? They've contacted us and they want this to be raised.
Well, at this point in time, we don't have any direct assistance for government, but obviously we are on a daily basis monitoring the situation and looking at what other types of initiatives we do need to put in place.
And just lastly from my side, in relation to the $150 assistance, there's a lot of people saying, of course, the exorbitant prices of vegetables and root crops, and they're saying $150 is not enough. Your comment on that? And whether it'll be really
well, at this point in time, these are the resources we've made available. There's obviously a lot more people who will come on board soon as we have more job losses. So we need to be able to stretch the dollar.
Thank you.
Thank you.
So just in relation to the lockdown, the Prime Minister made reference to how civil servants should face the consequences of breaching the directives on the restrictions on movement and the curfew. As Minister for Civil Service, even last night we had one civil servant arrested for breaching the curfew. What are your views on this, and what would you like to tell the civil servants?
Well, it's quite clear there's a general orders pertaining to civil service conduct. There's also the Constitution, which the Honourable Prime Minister referred to, in respect of the professional integrity of civil servants, and also the ability to uphold the law. Please refer to the Constitution. And obviously they need to be successfully prosecuted, and they need to be dealt with accordingly.
Have you sent out any memos or circulars to relevant heads of government departments in relation to this?
I think the law is quite clear in respect of them following the law, and therefore that'll be adhered to.
Has there been any discussion or any updates in relation to the lockdown of the Greater Suva area?
No, that'll be, please wait for the announcement of the Prime Minister. This is all specifically to do with the ruling by the Nandi Magistrates Court.
So just in terms of TC Herald withdrawal from FNPF, I understand that it was earlier announced that FNPF members can who are eligible for assistance can withdraw $2,000. But apart from that, what other assistance does government have for those who do not have FNPF accounts?
There's numerous assistance. As you know, the Minister for National Disaster Manager has already announced that, we're providing all sorts of things, including shelter and food, etc. So that's being done also.
So any help for those who will be paying insurance? They're required to pay insurance, any sort of subsidies given by insurance companies, or any talks with your ministry and insurance companies?
Not at this point in time. Thank you. Any other questions on the magistracy?
Just last one, sir. The senior accountant charged for breaching Ministry of Economy. Any actions will be taken?
All civil servants are treated alike.
So
All civil servants are treated alike.
So just lastly from me, there's a lot of talk about how government needs to provide funding or have cash subsidies for people who've lost their jobs. A lot of these workers are part of unions and associations, and these union representatives are also calling out for government to help. But there's been no steps taken by the unions themselves. They're not saying, look, we'll dip into our coffers and we'll give a bit of money to our members who've been paying fees and such. What are your views on how people are quick to sort of ask the government for help, but these union members and unions themselves are not willing to sort of open up their bank accounts for the members themselves?
It's probably one of the best questions you've asked, Edwin, and out of all of you. That obviously is something you need to ask the unions themselves and the executives of the unions. And you're absolutely right. None of the unions, unlike in other parts of the world, you have other union organizations that have come out. In many parts of the world, a lot of the unions come out and actually have a fund. They provide assistance to their members in times of strife, when there are problems. Obviously in Fiji that has not happened to date, regarding, at least in particular, regarding this pandemic. We've had submissions by FTUC, prior to the budget, as you know, that I mentioned that in Parliament. Many of those things we've already done in any case, which we think I had already thought about. But it's a very interesting question. I think you need to really ask them. I also understand that some of the people who are still working in the union dues are still being cut. That's something you need to ask the unions. And I'm sure they'll be available to talk to you.
Thank you, sir.
Thank you.